You go down to the county comptroller office and you get that financial statement on your case, and it's going to show the judges getting paid. Now, if he's getting paid on the county side, now you got his ass. The prosecutors, the judge, and all of them is getting paid on the county side. So that means y'all the judge, jury, and the executioner. You know what I'm saying? See, now that's a conflict of interest. So now you can take that financial statement, go and file it in United States District Court as a foreign judgment, get it stamped, then ask for a certified copy of that financial statement with the judge is getting paid on the county side, because he's not supposed to be getting paid on the county side, because why? He's a foreign official. He don't have the bond or the citizenship to be getting paid on the county side. So that means that the county is giving him what? A bribery check. So now you take that statement, file in the United States District Court, get a file in the foreign judgment, get a certified copy of that, and then file into your court case with the affidavit of a motion 473B, void of judgment for a judge for bribe on the tape. Now, three things gonna happen when you see that, and see that you got the U.S. Federal District stamp on it and a certified copy. He knows three things. One of the things he's gonna do, he's gonna recuse himself from your case, or he mess around and get disbarred from the Bar Association, or he can spend 5 to 20 years in the pokey. See, so anytime you catch them judges like that, just go down to the comptroller on the county division and get that. And if you get that financial statement, plug it into the case with a motion, with an affidavit motion 473B, void of judgment for bribe, for a judge taking bribe on the tape. There, it's done. See, once we start getting somebody really, you know what you say? It's chocolate. I'm still in there.
Can you hear me?
Yeah, I can hear you now. I couldn't hear you at all.
Okay, I was going to say, explain the breach of contract.
Okay, the breach of contract. All right.
Right.
All right. All right. Well, the breach of contract, we get back to my note right quick. Well, the breach of contract is basically what you're going to hit these folks with. Like, say, for instance, like y'all got some past cases, and you know what I'm saying, and it wasn't, and you know you wasn't done right, you know what I'm saying, and you want to know, man, how can I go back and, you know what I'm saying, get judgment. So let's say if you got a case, say a case could have been done 5 years ago, okay? When you go back in, what you want to do, you want to go in on a specific performance, which is a breach of contract. They breached the contract if they didn't put up the bond. That's how they breached the contract, because they never put up the bond. They supposed to have a bond put up on a carryover basis. So let me go back. You want to go in on a specific of a breach of contract. The breach of contract if they didn't put up the bond. They have to put up the bond to maintain and get out of the tax liability, and that's when you come in, and that's when you come in with those 5 discovery questions that I was talking about. You know what I'm saying? The breach of contract is when you made them fiduciaries under a Power of Appointment Act. You as the executive gave them an order to discharge the debt and pay all the proceeds to you. When they don't do that, they breach the contract. So that's when you can go in and make the complaint with the IRS, also make the complaint in with the SEC. Also, you send in the criminal complaints into to the Commissioner of Finance, the Insurance Commissioner of Finance, and also you send it in to the Governor, and also to the State Attorney General. Now let's say, man, my city, we got a crooked State Attorney General, man, the sheriff, you know, just like in Memphis, lockdown. Now you got to go over these people's heads now. Now you got to go after where they got their citizenship. Who they got their citizenship? They tied into the United Nations and the Netherlands. So now, here's the key people that you send these criminal complaints to get their bosses to come over here to get on who? To get on risk management, to get on these folks, get on their ass. And this who you send. You start sending the complaints to the Interpol of France. You send it to the worldwide police that's over the army that's over here. You send it to the International Common Law Court of Justice. You send them to the county rangers. You send them to the U.S. Marshals. Also, you send it to the United Nations Human Rights Division. Also, you contact David Johnstein, who is the right-hand man to the Queen, His Excellency. Also, you send it to the United Nations Human Rights Division. Also, you contact David Johnstein, who is the right-hand man to the Queen, His Excellency. He handles all the affairs of the Queen that owns the IRS. David Johnstein, you look him up. Ban Ki-moon is the president of the oath division that they all take their oaths to. And they take 3 oaths, 6 days apart. They take an oath to what? To the organic Constitution for the United States, for America. They also take oath for the Constitution of the state union and also the Constitution to the state.
Wow. Okay.
So this is that. Check this out. Now, if y'all, a lot of y'all may know, didn't know that the International Common Law Court of Justice back in March 5th sentenced the Queen of England 25 years in prison, sentenced the Prime Minister of Canada 25 years in prison, Prime Minister in Canada 25 years in prison, and that Pope that had to resign for meddling with all them, molesting all them children. Now, the Prime Minister and the Queen of England got sentenced to 25 years in prison. Y'all go back and look this up. For killing over 64,000 indigenous Canadian children at the schools. So this is what you bring these public officials to. Turn them in over there, man, in last common law justice. And go back and look in February when they got charged, and then May 5th, they had to turn themselves in 25 years.
I know when the Pope stepped down. That's what people don't. That's when the Pope stepped down. I mean, I thought it was some type of joke, but the Pope actually stepped down.
No, and you know what? And when I saw that, when I first saw that on news, I told my wife. I said, he stepped down. I said, yeah, he stepped down. Effing them kids. What? Why would you say something like that? That's what he did. I said, watch, he's going to come out in the watch. And a week or so, you're going to find charges. You're going to try and take yourself over there to the Vatican. About a week or so, man, I do this all the time. My wife was like, well, I don't know. How the hell you be knowing it? I said, the Creator Yahweh be telling me. I already know. And then next thing you know, boom, I saw it on CNN. Queen of England got charged. Prime Minister got charged. International Common Law Court of Justice. That's where I send my stuff to. And Alberta's Queen Bench Court. Now, if y'all got these crooked folks night judge, I'm going to tell y'all, write this down. Send your cases to Full Disclosure Network. That's like the CNN over watching all these crooked judges and these officials. What they do when you send your stuff to them, they'll put your stuff, they'll interview you, and they'll put your case out there. Right? Yo, you still there?
Yeah, I'm here. Can you hear me?
Yeah, I can hear you. I was just, I don't know if everyone else is hearing it through. It was coming, I don't know if they're messing with the frequencies and kind of chopping it, you know what I'm saying? So I was just, I want to know, do I sound like that on your end?
Yeah, at first you were, but now you're clear. But go ahead, just take over. You're real clear. Just go on and take over.
Okay. All right. All right. What I want to touch on is pretty much what everyone in this country is pretty much experiencing when you come into one of these agents or one of these private contractors, okay, which are foreign agents. And let me start off by saying that under the IRC Federal Reserve, Title 12, Section 411, there is no money, okay? And I want you guys to go ahead and start off and pretty much dot that down. You can look that up. But under the Federal Reserve Act, under Title 12, Section 411, there is no money, okay? And also, the people are the credit line, okay? That's McFadden, 1932, 1962, this is in court case. Law. Okay, people are the credit line, and signature is the money. Signature is the collateral. It is the money that is made off the property. The signature is what makes the money off the property. Okay, so these courts are committing inside trading, you know what I'm saying, act in which we should bring these judges, you know what I'm saying, and also these sheriffs on impeachment charges. Okay, now, let me say that once again, Title 12, Section 411, there's no money. Okay, McFadden, credit line, Supreme Court case, 1932, 1962, people are the credit line. Signature is the collateral, not the person. Money is made off the signatures, not the property. Okay? So I want to put that out there and just, and I want y'all to put that to the side because we're going to go in real deep. One thing they're violating is the Highway Safety Act and federal funding, which means 40% of the proceeds, when they bring you into court for any taxes or anything like that, that means that the subdivisions or the money that is put aside for the public, you know, whether each individual group based off your ethnicity, you know, have a right to this money, you know what I'm saying, and you're able to put the money back into the community, build your parks, your schools, and et cetera, what have you, which they are not doing. Now, I'm going to get into these bonds. Basically, with these bonds is, I don't care if it's a traffic case, whatever it is, criminal, mortgage, dealing with a lawsuit, anything. The bottom line is what they are targeting us and what we all are going to jail for is basically for tax evasion. Now, I'm finna explain this. We finna learn today what goes on. Now, on an alternate valuation, on a carryover basis, is why, the reason why, and I'm going to say this again, an alternate valuation on a carryover basis is why these attorneys and everybody who you deal with has a tax liability on their Title 26, 2032, capital A, lowercase e, 11, period. Please write this down so y'all can look this up and bring this up to these judges and these most attorneys, and a lot of them don't even know about this. Now, I'm going to say it one more time. An alternate valuation on a carryover basis is why these attorneys, judges, and everybody who you deal with has a tax liability, which is on their Title 26, 2032, capital A, lowercase e, 11. If you have a qualified error, which is what these attorneys and judges and all these public servants, because all of them are public servants, are claiming to be a qualified error on your estate. And it says it in subsection 11. If a qualified error makes a written application to the Secretary for determination of the maximum amount of the additional tax which is may be imposed by subsection C with respect to the qualified error interest, the Secretary, as soon as possible in an event within 1 year after making such application, shall notify the error of such maximum amount. The qualified error on furnishing a bond in such amount for such period as may be required shall be charged from the personal liability from the additional tax imposed by subsection C shall be entitled to have to a receipt or writing showing the discharge. Now, they supposed to give you a receipt when you go to court. They're supposed to have two receipts that they supposed to give you going to court. They supposed to give you a receipt from the money order transaction from the OID, which they are not filling out in court, which you supposed to apply, which is a 4490 form and a 3949A form, which in court these attorneys and judges is supposed to be filling out. So here it is. I'm finna go into what this actually means, and this is in the IRC, Internal Revenue Code handbook and guide, that they are specifically supposed to have a bond. Now, anything pertaining to a felony, your bond case may goes up to probably about $4 million, which means that they have to have a bond or either pay the liability disability on the tax bond, which is about $1 million, which comes out to about, on the bond, if they had the bond, they'd be responsible for $1.5 million on any federal felony case that they're trying to bring up towards you. Now, this is what I'll be bringing up and trying to get other people to bring up in court, is to ask these judges and these who is furnishing the bond in order to show that they have no tax liability. Is it me or you? You know what I'm saying? Do y'all understand that what the bond is? Okay? The bond is not the fact that they pay it off the birth certificate or what have you. It's the surety bond that they have to have, and as you as a beneficiary, you can demand that they have a bond in amount of no less than $100,000 to put up for the case. In your case, since the birth certificates are worth billions of dollars, then they need to be putting up $1 million per case. So let me explain that. If they have 10 cases, they supposed to have at least $100,000 bond per case. So that means they got to have a $100,000 bond for this case, that case, that case, that case. Whether if it's 100 cases, they do not have money or make enough money to be able to bring you into court and claim a charge against your estate. Not even one. So how all these courts feel when these folks are not insured? Because why? They gave up their citizenship and joined the foreign powers of the United Nations. So here it is. Mostly our problems come from where? From the police department. The sheriffs pretty much don't even bother you, but the police department, who is basically a private contractor, which they claiming that they represent 911. The color red represent Red Cross. Red Cross represents 911. The blue color, the light that they represent, that represent the blue waters that they coming over the ocean from the United Nations imposing laws on the land of the Republic. So anytime when they turn the blue lights on you as a living, breathing man traveling in your capacity, not committing a crime, they are not supposed to hinder you from your progress unless you committed a crime with your vehicle. Other than that, it's a felony for them to even turn the lights on you. So when they step out of their cruiser, they got a cruiser, that means a ship, they are trespassing on the land of the Republic, which means that they are no more than a man with a gun, period. And the sheriffs are allowing these people to do that. These folks are really ain't special gun. They only supposed to invest in crimes dealing with corporations or ocean, or when folks breaking ocean laws pertaining to a corporation. They're never supposed to deal with us as a living, breathing man or woman. But yet and still, they bring us into these courts. You know what I'm saying? First of all, if they bring a charge against you and arrest you, you're supposed to immediately go before a judge first, before you even go into booking and a holding tank. But yet and still, they hold you, kidnap you, get your fingerprints, force you into a contract on a bond, right? And that's the only way you can be able to release yourself in order to fight these criminal fraud charges. But what the point is, when you go into these courts, ask them, who has the bond, who is liable for the bond? Now, let me go into further, because I'm going to go in real deep, and I'm going to go into my so I want y'all to listen very carefully. Now, they have to have the bond. They have 100% tax liability on your estate. So what they're trying to claim that you must pay essentially what your statement illegally paid, then you have a 100% tax liability if they do not have the bond in place. It doesn't matter. It has nothing to do with the presumptive death certificate. They are claiming to be a qualified heir on your estate, which is the all caps name. They are saying that they can come in, rape your estate, but they don't get rid of their liability to do unless they put up the bond. And there are very few attorneys that know this, and I know how many judges probably don't know this either. But how many cases that you can go in and nail them on the discovery? You either put up or shut up. Either you have it or you don't have it. You know what I'm saying? Now, the thing is that these are some questions that we need to ask them or put into the contract. You know, when we put in challenging the jurisdiction as far as the writ of discovery, you hit them with that breach of contract if they don't put up the bond. They have to put up the bond to maintain and get out of their tax liability. And when you come especially when you come in and you ask them under discovery, do you have the tax liability for your alternate valuation on your carryover basis? You're claiming to come in here as part of my estate as a qualified heir. First of all, you're not even a qualified debt collector. You're out of running with that avenue a long time ago. So now on the carryover basis, can you put up the required bond to get out of your tax liability? Who has the tax liability? Me or you? It's always got to be them. They always, because they're the one that's bringing the fraudulent charges. So you don't have to put up the bond, and they do. Okay? So what you do is you ask the judge, you know what I'm saying, who is raising the estate. And 9 times out of 10, they're going to put it off on the prosecutor attorney. Then you turn to the prosecutor attorney. Do you have the 1040 for this case? You have the 1099-A acquisition and the cancellation. Have you filled out the monetary order, and have you paid the necessary $1.5 million in order for you to deal with this case? If not, I'm taking care of that immediately with the IRS, filling out the 3949A form with the W-9 as the cover sheet, filling out the 27 form, send it to both places of the whistleblowers. You send it to the United States CID, which is the Criminal Investigation Division. You also send it to the Treasury Inspector General and the State Attorney General. Okay? And that's how you nail these suckers, you know what I'm saying? By turning their ass in. You know what I'm saying? Because they are not supposed to be in these courts because they are not licensed and insured at all. And they do not have the bond. So nobody ain't supposed to be in these court cases at all. So that's why now it's very understood when you stand on your square and you tell them you don't understand, and the judge and them go berserk, schizophrenic crazy, and then they want to hold you in contempt and send you off to a mental evaluation, which is schizophrenic because they knowing that every time that they come in that court and they sit in there, they gambling. They gambling with their livelihood and they gambling with their life. And they know this. You know what I'm saying? And they know this. So, and think now. Hello?
Are you still there?
I'm saying is what we need this thing. If all of us get together and come in on this tax thing on these folks, I'm telling you, right now, all them judges and them prosecutors and all them attorneys, there's going to be a long-ass soup line for them. And they're going to spend plenty of years in the pokey. See, this is not what we bringing up. You know what I'm saying? About the tax liability. Now, I'm going to give you all examples. Like, okay, now, you know, I hear what he's saying, but you know what I'm saying? I kind of hear what he's saying. All right, so let's switch. I'm going to give you an example like I was talking to Brother Yusuf the other day. I'm going to give you all an example. And I want y'all to kind of put the players in the same place that I'm about to use this example. Let's say Game Show Price is Right. Okay, everybody pretty much know about the Price is Right. Okay? All right. Now, you got the investors, the sponsors, the directors, the executives that's coming up with this idea for this game show, which is the Price is Right. They are the investors of this game show idea. But the people is the one who is the customers that's going to pretty much fund the investment because they looking for a return on this. So now, they game show is consists of they buy all these prizes and gifts and trips and stuff like that. And when you know you purchase anything, you have to pay the taxes on that. So they're never planning on paying the taxes. That's where you come in as the contestant and the participant. You pay your little money and your little entry fee, okay? And then you get on the game show, and they tell you to come on down. So now you're a contestant, you pay the entry fee. That means you're a co-beneficiary to the Price is Right. They are the executor, right? They claim to be the executor, but you are the co-beneficiary, right? Now, check it out. Say you win $100,000 in prizes. You win trips over to Switzerland, wherever it may be. You don't win furniture, brand new car. You don't want some skis, and hell, you don't even go skiing. Here's the catch. You didn't read the fine print when you paid the little money as the entry fee to be what? A co-beneficiary, said that you will be liable for the taxes for whatever prize and earnings and winnings. So here it is on $100,000. You're not expecting that you were going to have to pay $10,000 for the taxes on the proceeds in order for you to what? Get the prize and stuff you win. You don't pay the $10,000, you don't get the prizes. But they hold you responsible because you signed a contract. Now, let's say, for instance, they never did got anybody participate in the Price is Right. Who's responsible for the taxes for those gifts and stuff that they bought? They are. Now, you get my point? So they the one that's initially responsible for the liability and the taxes. So that's where your signature, they come in to bully you into signing the money order process that you never see, which is that they saying that you're responsible for the $1.5 million taxes on the case. So that's why you as the trustee sits in there in the pokey. Now, the amity courts that they use and set up, they use equity and trust law. They always turn it over to trust law, so they're using the Holy Trinity in these courts. So what we have to do under the Power of Appointment Act of 1951, we have to rebut the position of the trustee that they already set it up. Now, when you go into court, you got the judge, well, so-called judge, the prosecutor who is the crown, and then they got you. So they got the Trinity set up in court. Now, if you read the scriptures are set up the same way with the pyramid. At the top, you have the grantor, who is the father, the creator. Down on the left, you got the son, who is the beneficiary, who is the grantee. Okay? Then you have over here in the right corner is the Holy Ghost. It's the ghost. You got the living, breathing Father, living, breathing man, but you got the ghost over here. That's not entitled to anything. Now, you put those same pieces, plug in where the Father at, the judge is sitting up there. He done put himself up there as the executor or the grantor. The crown or the prosecutor is over there in the corner where the Holy Ghost is, but he claims to be the beneficiary. He's not a living entity. He's an agent. So what he's claiming for damages, and he's claiming the police, claiming all the proceeds and for you to go to jail. You over there, that's supposed to be the beneficiary, you sitting over there as a trustee because that's how they set pieces up in court. What you have to do is rebut being the trustee and be the executive and the beneficiary and point them as fiduciary trustees over all said matter because they are the public servants. They are the trustees. And they can't get out of this. And this is trust law that they can't get out and they can't break. Okay, let's go a little further. So it's based on them dealing with the trust in the estate. So here it is. They're coming in, claiming to be the estate beneficiary, so we have to rebut that. And one way you stop the cases is ask them for these taxes on these liabilities and ask them for them 1099 and them bond forms. See, and a lot of times they ain't even finna be too serious with that because they know where you finna go with that. They know you're a little bit too smart and you done figured out that, hey, man, y'all the one responsible for the tax liability. Y'all filed an insurance claim on me. Y'all got to prove the damages. Where's the injured party? But there's only three reasons why I want you to come to court. Injury to the body, injury to property, or breach of contract. Y'all have none of those three. Now, let's go any further. So I want to take that Price is Right so far as paying the taxes. This is what they're doing to you. Same scenario. Now, when you have the money order to take care of, the IRS forms, you know what I'm saying? Go ahead and attach the 4490, look these forms up, and also the 8281. These are the forms that the courts are supposed to have and fill out. Forms, you know what I'm saying? Go ahead and attach the 4490, look these forms up, and also the 8281. These are the forms that the courts are supposed to have and fill out. And these are the receipts, you know what I'm saying, from the OID. And I'm going to go over how to fill out these money orders in 1099s, and I'm going to go over them step by step too later on in this conversation so we can get that right, so we can show y'all how to take care of this on the finance side. Okay? Now, also, what I want to go into is that let's see. I'm going over my notes right quick, because I was talking off the top of my head, so I'm trying to get back on where I'm pinpointing these notes. All right. Now, the OID money order process instructions, the OID, which is outstanding issue discount. The courts must file the 1099A acquisition and 1099C. Both of these forms shows that you are the beneficiary, all right, and that they are not just receiving a gift and not paying the taxes on it. Now, the 1090 acquisition and the 1099C, also you file in what is the 1099 OID, and you follow up with the W-9. Now, I'm looking at my 1099. I got a 1096. Now, the 1096 form is supposed to go with every one of these forms, cover sheet. Okay. Now, I'm looking at if you had a 1099 form in front of you, it would say pairs at the top box, name such and such. You will put the all caps name. The address of the all caps name will be the birth certificate file number, because that's the only address that the all caps name and residence can be. And then the city and code will be the address of the state, city and state that you was born in. Okay. Now, the recipient name is going to be you, and then the payee is going to be them. So it's going to be your board of directors. You're going to include all the judges, all the attorneys. You're going to go back and include the state attorney general, the governor. You're going to go back to your birth state if you're in another state, and you're going to include the state attorney general. You're going to include everybody that's involved, as far as the hospital, the directors, because these are the people who started and sold into slavery when they made your mom an informant with that birth certificate. So you got to go back and point all of them under fiduciary. It goes back to the birth state, to the hospital, to whoever was the CEO of that hospital, who was the lawyers at that time, whoever signed on that birth certificate. You put all of them, and you put the lien on all of them suckers, because they are the one that's responsible who started putting you in that 14th Amendment category with that birth certificate, with that nonsense. All right? Now, this is also what I want to get into after, and what they do, they turn you into a note, a warranty and a deed, okay? Now, Section 7201, this is the law in the IRC manual that states that any person who will fully attempts in any manner to evade, defeat any tax imposed by this title or payment thereof shall, in addition to other penalties provided by law, be guilty of a felony. Upon conviction thereof shall be fined no more than $100,000 or $500,000 in cases of a corporation, or in prison not more than 5 years or both, together with the cost of persecution. Now, this is a nasty part not giving the W-9. They're supposed to have the W-9, so you ask them for the W-9, you ask them for their EIN, you ask them for their tax identification number. You know what I'm saying? You ask them for these in court, okay? Now, you have defense and recoupment and set off of debt when you do this. And this did not disclose their true identity and not being a holder. You was the actual holder, not them. So they didn't have the bond in place. They couldn't meet the qualifications of the qualifier error. They never transferred anything into the REMIC, R-E-M-I-C, which is real estate, mortgage, investment conduits, where the tax return in the REMIC for the trust, they have to produce the trust tax return. They can't do it. They won't do it because they know they didn't transfer anything. So that's when you get into the 7201 violations. And you get into all the other criminal violations that you document on the 4490 form, and you take them and say, fine, you're going to sit behind in the pokey. You're going to do a lot of damn years for your tax evasion, because you are traveling in the community as a disguise on American Express, Inc. or Visa, and you not have paid anything to overcome your insolvent disability. When you gave up your citizenship, you became a citizenship to another foreign land that has all the 4 elements that makes a country. Now let's deal with the 4 elements that makes a country. You have to have a name, in order to have a name or a country. You have to have people. You have to have boundaries. You have to have money. You got to have money. This country ain't got no money. So that means that everybody is what? Pre-tax exempt. You tax exempt because there's no money. See? So you can take the same damn dollar that's in your pocket, that is a Federal Reserve note, which is an IOU note. You can take a damn piece of paper and write, I owe you $1,000. MBS, mortgage-backed securities. Or put TS on there, treasury bonds. And you should be able to use that and pay your bills and discharge your debt, which you can. Because why? It's a negotiable instrument. If you any of your all that, all you got to do is take their ass to court, sue them under Title 42, civil rights violation, negotiable instrument, bam. Public Law 7310, Chapter 48, Statute 48 through 112. That's the law you argue in court about the debts being paid off under Emergency Bankruptcy Clause Act of Roosevelt of 1932. That public law right there is what you argue about your mortgage, your house being paid off, your vehicles, your cars, anything. That law right there, they can't get out of. That's the whole HJR 192 House Joint Resolution. All that's up under that law, under that title law. Now, let's get back to these violations. Now, you want an unlawful detainer, and what they claiming, they filing quiet titles on you. Okay. Now, you can hit them by them not being a qualified debt collector. Now, let's get back on that. Okay. Now, what we want to do is we want to also take these questions. Now, I want people to listen to these questions very, very carefully. And these are some questions that you usually discover. Okay? Now, in a lawful detainer, and them not being a qualified debt collector, okay, with not being a holder in due course, laundering of money instrument, that's USC 1956. There are so many sections where we can go in and file suits against these people. You know what I'm saying? These companies, we go in, we can hit these banks and everything, and these court systems for these money laundering and senators' crime in perpetuity. I say accept everything, okay? When you go in court and I say, I accept everything you've done to me on the proof of claim that, number one, that I am a decedent, that I have accepted the liability of the decedent, that I am not the beneficiary of the estate, and that you do not have a tax liability for the ultimate valuation on a carryover basis, and that you have put up your bond for your tax liability. And finally, that you are not making a claim on my estate. Now, you can answer those 5 questions, which they're not going to be able to answer. You took my estate, you took my gift, you took my signature, you took my security note, and you didn't pay the taxes on the gift. Therefore, you did all these nasty-ass things, so you want to go to jail, spend 20-some years, $500,000 fine, not just for the money laundering, but go in and pay the penalties on the 7201 and all the penalties on the 7206 and all other things. You know what I'm saying? Now that's real firepower. See, this is what y'all need to be going in the court with this information I'm talking about, and go back and listen to this and go back and do the research and look this stuff up and then go to court. Because this real firepower that they ass is in trouble. This is what they fearing every day when they go into court. The reason why they not fearing any recusals or anything like that, because we have hit the education intelligence level below 70. So that means we are pretty much illiterate and ignorant to the law. So as a saying, if you saying you have rights, right, and they ask you what are they, and you can't tell them, a man or a woman that can't explain or explain in law that he has rights has none. So mostly all of us has been dumbfounded, and that's why they able to come and run this sinister game of perpetuity in the courts on us, because we have failed to educate ourselves properly. It ain't for these school systems to educate us. You know what I'm saying? Because we sit around and we waste a lot of time doing dumb shit. Now, money laundering, you can look this up, laundering money instrument under USC 1956. Okay? Make sure y'all look these up. Look up section 7201, 7202, 7206. Get to know these violations, Irish violations, because this is what we're going after these folks for. Okay? Under USC 1956. Okay? Make sure y'all look these up. Look up section 7201, 7202, 7206. Get to know these violations, Irish violations, because this is what we're going after these folks for. Okay? All right? Also, Title 26, 2032, capital A, lowercase e 11, is once again is where they have to have a bond. They have to get a letter and a receipt from the secretary that they are tax exempt. If y'all get 26, 2032, capital A, lowercase e 11, is once again is where they have to have a bond. They have to get a letter and a receipt from the secretary that they are tax exempt. Did y'all get that? They have to get a letter and a receipt from the secretary to say they're tax exempt. Now, who's the secretary? That's a big question. The secretary that everyone talked to and his credit and all them is the Secretary of Puerto Rico. So the laws and legislation that they are governing us under and making us be 14th Amendment citizens under our knowledge and knowing, we are being brought under the jurisdiction under the legislations of Puerto Rico. And you can find that in the IRC Penal Code, Title 27, Section 280.11. And there are And if you, and I'm gonna tell you, in 2011, they took that off the website. So you'll have a hard time Googling. You can come to it, but they done scratched it out because they know you can use that title right there alone and come into court and nail their ass. Because we over here, under the laws that's protected under the Constitution in America, but you trying me for some legislation laws under the territories of Guam, America Samoa, the Virgin Islands, Puerto Rico. But y'all guys need to look this stuff up. This real firepower right here.
Hey, let me interject right there. I mean, that was beautiful how you just laid that all out. I think a lot of people need to understand that jurisdiction of the United States is different than the republic. When you say republic, you're talking about the democracy. The United States is Puerto Rico, American Samoa, Guam. These are territories.
Yeah, all caps United States.
Exactly.
We're talking about the lower caps. We ain't talking about the lowercase United States for American Republic. See, any time you're dealing with democracy is another name for mobocracy. Or mobocracy. Democracy is another name for mobocracy or mobocracy. So break those words down. What cracy means? Cracy means to rule. Demos. What's demos? That comes from the word demon. So the people is ruled by the demons. How are you folks out there claiming to be Democrats? So you being ruled by demons. Yeah, go ahead, you should go ahead, get back and go ahead, elaborate. Go ahead, elaborate.
Yeah. No, I was just, you're absolutely correct. Right now, what I'm doing is I'm studying prefixes of words because the grammar that we use is incorrect as well. I had a chance to talk to David Wynn Miller personally, and I'm going to try to have him on the show too. But that's another thing that's come to my realization when you just said that we broke down democracy. That's absolutely correct. That's why I was telling you yesterday on the show, women want security. The way secure means away from. I mean, it's away from any kind of care. You don't want love or anything. The words don't mean what we think they mean. They have absolutely a different meaning. But man, that was beautiful how you broke that down. I don't think people need to go back and listen to the audio very carefully. Look up everything that he's saying. There's a document I'm trying to look at right now because I was looking up some stuff where some other people have been kind of saying what you're saying. There's a document called Nature of the Remedy where it's asking them for these 99 OID issues, this W-9, and I never understood. I'm not when it comes to taxes. Taxes just I can do nothing with the taxes. But I knew that it was a tax liability that they had to have, and I knew they had to have a bond. But the way that you just explain the intricacies of how that works, I mean, I understand it perfectly. It's beautiful. It's real beautiful.
I appreciate that, my brother. Appreciate that. And then I'm gonna eventually go into how these bonds are securitized, and then take y'all on the little roller coaster that it go. And I'm quite sure you already know, but for the folks that really trying to get it and listen, you know what I'm saying? So I want us to be very, patient with that. If we got to, hear the same thing.
Man, go ahead, man. The floor is yours, man. Because I'm gonna go back and listen to this. So go ahead.
Right. I'm very humble, man, and I'm very passionate, man. So I'm just, I just want folks to get it. So I just want to make sure that everything is 100 and good. So, but yeah.
Good morning, fellas. Let me chime in real quick. Good morning, my brothers.
Good morning, Paul.
Hey, Joshua, do me a favor. Give me them five discovery questions slowly so we can write them down.
Okay. All right. Ready?
Yeah.
Okay. The 5 questions. All right. Now this is what we're gonna go back with. Write this down. Okay. And your unlawful detainee. Okay. As them they come in as a claim to be a qualified debt collector, which they're not. So we can come in as the heir. You know what I'm saying? And hold it in due course, laundering of the money instrument. So there's many sections that we can go in and we can file suits against these people. Okay? So I'm just pretty much repeating, you know what I'm saying, the same thing. So, and we can go in and say, I accept everything that you've done to me under proof of claim under these discovery questions. That number 1, that I am a decedent. Number 2, that I have accepted the liability of the decedent. Number 3, that I am not the beneficiary of the estate. Number 4, that you do not have a tax liability for your alternate valuation on your carryover basis, and that you have to put up your bond for your tax liability. Judge, attorneys, clerks, all public servants. That goes for you. And finally, that you are not making a claim on my estate. Now, if they can answer those 5 questions, they're not going to be able to. Because why? They took your asset, they took your gift, they took your money, they took your security note, and they ain't pay no taxes on it. And they left you with the bill, the tax bill. See, this is very nasty. See, this is what these prosecutors are scared of you coming in and asking them in court. And they know if they keep us ignorant, you know, they keep on running this game. They don't have to go to work. They can sit down on their ass and play paperwork game, and they don't want to work. That's all it is. They want to push paper.
Now that was very interesting. That was very interesting. We're talking about how they're foreign too, because that's absolutely correct. They've given up their citizenship, and they have joined another country. Basically, they're foreign. They've joined. It's almost treason. Would you say?
Right. So check this out. So therefore, they join another country. They got to pay taxes to that country because they working for that country. So what they doing is they don't want to pay the taxes. They ain't nothing more than drug dealers. You know what I'm saying? So what's the difference when a drug dealer ain't working? He take the money. He go buy a $60,000 car, and then the car dealership, the owner is gonna protect his ass because why? He gonna fill out the 1099A form, 1099C, the 1099. He gonna do the 1040 morning order, and he gonna put the form 8300 on it because it's anything over $10,000 at that time. Now it's probably down to $3,000-$4,000, but at that time, it's anything over $10,000. You report to that. It goes to the IRS. That's when the feds come get you. Same thing. They working. They got bar membership. That's their registration through the bar. You got 2 corporations. 2 Englishmen and European came. They started what? The Bar Association Corporation and the United States and All Caps Corporation. So they are evading paying taxes for who they work for.
They got us paying the taxes.
So they just switch. That's why when you go in court, they set up trust law. They turn amity court into trust law equity court. But you want to keep it in equity because once you rebut them out of them positions of being executive beneficiary, you want to lock their ass in on their Power Appointment Act. See, now they can't switch it over to amity or none of that. See, they locked. They stuck.
Okay, well, let me ask you this. Okay, what about, when you file that into the case, all right, sometimes I've had situations where they ignore when I'm coming in and appoint them with an form. Would you recommend using a Form 56 to appoint?
Right. So this is what I do. Like, say, for instance, like when I was starting off early, before I figured out to do my court, you know what I'm saying, on the administrative side, see, your notary, get your private notary. Your notary is a deputy judge, secretary of state. The notary is over all the clerks, they're over all the attorneys and the judge and prosecutor. They over them. They got more power than them. So when you come over the power appointment, you come from your office and her office, or the notary office. You see what I'm saying? But when I used to go in there, I had to battle this when I was learning in the field and shit going in there. See, what I use what they call a trust res. Trust res document. You know what I'm saying? And under the trust res or the Power of Appointment Act, I appointed all them trustees. I got a trust res so fast, they can't even get out of it. It ain't even doing no talking. You see what I'm saying? Because when you go in there as an executive, it's no talking with them documents. See, they want to get you to argue. See, it's like they see it's like an amity. I want to put it. In amity, they see nothing. You see what I'm saying? But they hear everything. But in equity court, it's the opposite. They hear nothing, but they see everything. You understand what I'm saying? So and you like, what the fuck? So you got to know what court, you know what I'm saying, what court are you dealing with? You need to know the cause of action. Like, what court of law am I dealing with? All right, I'm dealing with a criminal. Well, where's the injured party? Where's the injured party? Oh, we're dealing with civil? Oh, we're dealing with civil? Oh, well, shoot, at our point where we're turning this into equity, I point y'all trustees. Over this said matter. I'm delivering breed to such.
Wow.
But I hit them with that trust res document that appointed my trust. And now check this out, under the trust res document. And then I hit them with the 56 fiduciary form. I hit them with the W8 bin. Also, I hit them with the 7525B. I do all the monetary outstanding, which is I do the 1099A, I do the 1099C, I do the 1099 OID, okay? Then I hit it with every 1099-6 cover sheet form. So I take care of the IRS part. So first copy going to go to the IRS, second copy going to go into the court case. Second copy is yours. Then you hit them with that breach of contract and that letter rogatory. But when you file that trust res, you don't do no talking. The only thing, when they call you up, you step up. I'm the executive, such and such and such. I'm the executive, beneficiary of the all caps name estate, property of the state, such and such, such and such. I am the living, breathing appointed of God's last will and testament. I appoint you, the clerk manager, as trustee, who appointed this judge as the trustee residing over this case, and the prosecutor as trustee in this case, and to pay $1 million and to pay all the beneficiary and proceeds to me. And you don't shit after. You sit your ass down. You don't say nothing. Because they see everything and they hear nothing. After that, they try to get you to argue and such and such. When they ask you a question, do you understand such and such? Do I have standing to speak? Yeah, you have standing to speak. Pay the beneficiary. Dismiss all charges to the case. That's it. That's all you got to say. And I guarantee you, when they shit over with, they say, well, I had to just leave the courtroom. I have a brother that can call in right now and tell you, I had to just leave the courtroom. I'm sitting there arguing without my $14 million check. Because you can ask them, listen, check this out. When I filed that trust ring, I left something out. When they ask you, or they call your name up, blah, 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 and want you to swear. Man, I don't raise my hand. I don't swear none of that garbage y'all talking about. James chapter 5 in the Bible, Yahweh said you take no oath and swear to no one. You let your yes be your yes, your no be your no. Oh, shit. I affirm whatever I need to be said. Now, carry on. Then next thing you know, such and such, do I have standing to speak? Do I have standing to speak? I am Yahshua Israel Yahweh. I'm the executor, beneficiary of the such and such estate. You are all appointed trustees under Power of Appointment Act. This manager appointed you trustee, judge, appointed this attorney trustee. All y'all pay the beneficiary 1.5. Dismiss this case, for my spirit existed long before my body. I am the beneficiary of the Creator's last will and testament. Now, this is the key fact. Now, they'll mess around, blah, 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 blah. You know, they're going to put on some steam and stuff. I sit right there and look at them and smile and everything. I don't come across that bitch and anything. When they ask the question, like they still trying to be the executive because they're trying to tell you what to do to punk you out of your executiveship. Because if they can get you to answer the question, now you revert back to being the trustee. So you be very careful not answering no questions. So when they answer a question, you ask a question with a question. When they answer a question, blah, 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 blah. Do I have standing to speak? Now, I just appointed you under the Power of Appointment Act, who all are the trustees. So now I'm going to ask, who is the trustee in this case? Now the judge going to fly off the handle. I'm warning you. I'm going to hold you in contempt. I'm telling you, I'm holding you in contempt. You're going to 30 days. 30 days. You want to ask you a quick, do you understand? See, anytime they ask you, do you understand, they ask you, are you liable for the bond? So they slick. They come in, they coming at you, you know what I'm saying? Do you understand? Do I have standing to speak? Do you understand? Do I have standing to speak? Because I'm asking the question with a question because I'm staying in the what? Staying as the beneficiary. Yes, you have standing to speak. Going on the record for the second time. The judge and anyone has not responded to the question is who is the trustee in this case for the second time. Now, if you got to ask that question 3 times for it on the record, the judge, the sheriff is supposed to take that judge out of the courtroom, put handcuffs on him, and take him straight to jail, and he know this. Now, if this is how you're supposed to do this, if you know you got a case that you know you got a judge in there that's going to be violating the Smith Act and running the Harley Act, the first thing you need to do is contact the head sheriff and let the sheriff know about your case coming up, and let the sheriff know that you need all his bailers to not get involved when you go in on the judge, because the judge is going to be committing felony, which is a Title 28, Section 454, 455, which means he's going to be practicing law from the bench. And I'm telling you that you're supposed to lock his ass up because you're on the county side. So the sheriff will go, oh, I didn't know it, such and such. So you put his ass on notice and let him know that I'm going to file a 3949 and I'm going to file criminal charges against you because I'm a living, breathing man and you're not protecting my right that's under the Constitution that you took a half for. So you taking a bribe on both sides. So when you tie the sheriff in, he don't call them bailiffs that's working that floor in court. Look, so going to come in. Y'all just sit back and don't do nothing. So that's how you keep them bailiffs off your ass from locking you up. Talk to that sheriff. Put him on notice first, on ice.
You know,
then when you go in, now you can go in and do your thing.
You know, that's an interesting thing. Our listeners may want to know that the police and the sheriff, I mean, people need to learn. Like, I used to, when people get their car repossessed, I used to make a mistake and tell people to call the police. And every time the police would come, they'd be trying to talk the person into giving his tow truck driver their car. I said, hey, you're the police. But then it dawned on me that the police are not there to protect you. That's the sheriff's job. The police are there to protect everything for the corporation. The bank. The police work for the bank, not for the people.
Right. So how you guys stop a lot of that nonsense, them lock you up when you know you reached on the truck? You're supposed to always do court with the sheriff. because the sheriff is the ones that got this nonsense going on in the courtroom. So that's how you know sheriff taking the bribe. That's how you know you got a crooked-ass sheriff. So he needs to be impeached. He needs to be ousted. You understand what I'm saying? That's how you know you got a crooked sheriff wearing both hats. He wearing the corporate hat and he wearing the sovereign hat.
Well, wouldn't you say that the judge is also wearing two hats? Because these are Article 1 courts, but we do have some Article 3 judges, like the judge took the oath of the Constitution as well. So wouldn't the judge also be wearing two hats?
Well, what happening with the judge is, see, the United States Department of Agriculture is paying all the feds, IRS, judges, public officials. They paying their money, right? The risk management is over all that division. So what it is that the judges and them is getting paid on the state side. So when you have a judge that is corrupt, now say if you guys out there that got some cases going on, and you go into court, and you knowing this judge here is violating Title 28, Section 454, 55. You know he's practicing law from the bench. You know he's committing fraud. You know he's committing treason. You understand what I'm saying? And it's a reason for that. So what you do is, that's a judge that's been taking a bribe. That means he's getting money paid on both sides. That's what you mean by wearing both hats. So now what you need to do is, you need to go down to the county comptroller's division office on the county side, county comptroller division, and you ask them folks for a request, which is pretty much similar like a 2046 balance sheet. But you're going to ask them for the financial statement on the case. Look, my case number, I need a financial statement on on how much this case is. They're going to give it to you. And you know what I'm saying? You might have some that sit there and play games and shit. You get their name, ask their name, say, look, I'm going to file a Title 42 lawsuit on, you know what I'm saying, for violation of due process of rights. You know what I'm saying? Hit them with the amendment. They ain't gonna want to play no games. So you talk to for the supervisor, they gonna go ahead and give you what you want and file it because they want their jobs too. You understand what I'm saying? So you don't waste your time talking to the clerk who don't know nothing, the person at the desk. You don't know nothing. So waste time with them. They always tell them what to tell you so they can hurry up and turn as many people away. But what you do, you go down to the county comptroller office and you get that financial statement on your case, and this gonna show the judges getting paid. Now if he's getting paid on the county side, now you got his ass. The prosecutors, the judge, and all of them is getting paid on the county side. So that means y'all the judge, jury, and the executioner. You know what I'm saying? See, now that's a conflict of interest. So now you can take that financial statement, go and file it in United States District Court as a foreign judgment, get it stamped, then ask for a certified copy of that financial statement with the judge is getting paid on the county side because he's not supposed to be getting paid on the county side because why? He's a foreign official. He don't have the bond or the citizenship to be getting paid on the county side. So that means that the county is giving him what? A bribery check. So now you take that statement, file in the United States District Court, get a file in the foreign judgment, get a certified copy of that, and then file into your court case with the affidavit of a motion 473B, void of judgment for a judge for bribe on the tape. Now 3 things gonna happen when you see that and see that you got the U.S. Federal District stamp on it and a certified copy. He knows 3 things. One of the things he's going to do, he's going to recuse himself from the case. Or you mess around and get disbarred from the Bar Association, or he can spend 5 to 20 years in the pokey. See, so anytime you catch them judges like that, just go down to the comptroller on the county division and get that. And if you get that financial statement, plug it into the case with a motion, with an affidavit motion 473B, void of judgment for a judge taking bribe on the tape. There, it's done. Once we start getting about it, really? You know what you say? It's chocolate. I'm still in there.
Can you hear me?
Yeah, I can hear you now. I couldn't hear you at all.
Okay, I was going to say, explain the breach of contract.
Okay, the breach of contract. All right.
Right.
All right. Well, the breach of contract, we get back to my note right quick. Well, the breach of contract is basically what you're going to hit these folks with. Like, say, for instance, like y'all got some past cases, and you know what I'm saying, and it wasn't, and you know you wasn't done right, you know what I'm saying, and you want to know, man, how can I go back and, you know what I'm saying, get judgment. So let's say if you got a case, that case could have been done 5 years ago, okay? When you go back in, what you want to do, you want to go in on a specific performance, which is a breach of contract. They breached the contract if they didn't put up the bond. That's how they breached the contract, because they never put up the bond. They're supposed to have a bond put up on a carry-over basis. So let me go back. You want to go in on a specific of a breach of contract. The breach of contract, if they didn't put up the bond, they have to put up the bond to maintain and get out of the tax liability. And that's when you come in, and that's when you come in with those 5 discovery questions that I was talking about. You know what I'm saying? The breach of contract is when you made them fiduciaries under a Power of Appointment Act. You as the executive gave them an order to discharge the debt and pay all the proceeds to you. When they don't do that, they breach the contract. So that's when you can go in and make the complaint with the IRS, also make the complaint in with the SEC. Also, you send in the criminal complaints into to the Commissioner of Finance, the Insurance Commissioner of Finance, and also you send it in to the governor and also to the state attorney general. Now let's say, man, my city, we got a crooked state attorney general, man, the sheriff, just like in Memphis, lockdown. Now you got to go over these people's heads, man. Now you got to go after where they got their citizenship. Who they got their citizenship? They tied into the United Nations and the Netherlands. So now, here's the key people that you send these criminal complaints to get their bosses to come over here to get on who? To get on risk management, to get on these folks, get on their ass. And this who you send. You start sending the complaints to the Interpol of France. You send it to the worldwide police that's over the army that's over here. You send it to the International Common Law Court of Justice. You send them to the county rangers. You send them to the U.S. Marshals. Also, you send it to the United Nations Human Rights Division. Also, you contact David Johnstein, who is the right-hand man to the Queen, His Excellency. He handles all the affairs of the Queen that owns the IRS. David Johnstein, you look him up. Ban Ki-moon is the president of the Oath Division that they all take their oaths to. And they take 3 oaths, 6 days apart. They take oath to what? To the organic Constitution for the United States, for America. They also take oath for the Constitution of the state union and also the Constitution to the state.
Wow. Okay.
So check this out. Now, a lot of y'all may know, didn't know that the International Common Law Court of Justice back in March 5th sentenced the Queen of England 25 years in prison, sentenced the Prime Minister of Canada 25 years in prison, Prime Minister in Canada 25 years in prison, and that Pope that had to resign, meddling with all them, molesting all them children. Now, the Prime Minister and the Queen of England got sentenced to 25 years in prison. Y'all go back and look this up. For killing over 64,000 indigenous Canadian children at the schools. So this is what you bring these public officials to. Turn them in over there, man, in Common Law Justice. And go back and look in February when they got charged, and then May 5th, they had to turn themselves in 25 years.
I thought when the Pope stepped down, that's what people don't, that's when the Pope stepped down. I mean, I thought it was some type of joke, but the Pope actually stepped down.
No, and you know what? And when I first saw that on news, I told my wife. I said, he stepped down. I said, yeah, he stepped down. Effing them kids. What? Why would you say something like that? That's what he did. I said, watch, he's going to come out in the watch. And a week or so, you're going to find charges. He's going to try and take himself over there to the Vatican. About a week or so, man, I do this all the time. My wife was like, well, I don't know. How the hell you be knowing it? I said, the Creator Yahweh be telling me. I already know. And then next thing you know, boom, I saw it on CNN. Queen of England got charged. Prime Minister got charged. International Common Law Court of Justice. That's why I send my stuff to. And Alberta's Queen Bench Court. Now, if y'all got these crooked folks might judge, I'm going to tell y'all, write this down. Send your cases to Full Disclosure Network. That's like the CNN over watching all these crooked judges and these officials. What they do when you send your stuff to them, they'll put your stuff, they'll interview you, and they'll put your case out there.
And today I'm going to be discussing some criminal aspects of this redemption thing that we're going through. You know, when I was first brought into this, and I was being constantly told that it's not really criminal, it was civil. I was listening to Gene Keating. He said it's all civil, it's admiralty. The jurisdiction of admiralty is civil. And to get away from the conspiracy theory thing, because it's like, oh, that's conspiracy theory. So so what I started to do is I said, you know what? I'm gonna start looking in their law books and see if I can find some evidence that all of this is real, utilizing their law. And I kind of took from a video called "The Occult World of Commerce" that I have posted here on my YouTube page, where Jason Whitney was saying it's like an overlay. What they're doing is like an overlay, and I always remembered that. So as I progressed in my understanding of all of this information, I started to notice some things. It's the words. They hide everything in plain sight using the words, and you got to also know how to cross reference, the statutes and so forth. Everything's not in the same statute, like the criminal code and so forth. And I'm going to show you that in a minute. Like here in Georgia, Title 17 and 18 go together. But if you don't know that, you'll never look in Title 18. You'll only stay in Title 17. I'm going to show all of y'all what I'm talking about, and hopefully you can utilize what I'm going to show you in your own respective states, and start doing some deeper research for yourself. Now, I started doing this in Georgia because I was I was doing some state cases here in Georgia, and I was studying Title 17, which is criminal procedure in Georgia, and I came across a real interesting law, and I'm going to show you the difference also why you go to the law library versus staying on the internet, looking on the internet and looking up stuff on the internet. You're really not going to get everything that you need. So let me show you this real quick. Okay, I'm back, and I found something in the Georgia code that was very, very interesting that led me on my trek of investigating all this information on a deeper level. And it's OCGA 1711-1. And what made me even start looking at this was a document called Creditors in Their Bonds, the hot potato game. And let me read that for you real quick before we do this. And this is coming out of a document called Creditors in Their Bonds. And it's a section that talks about the hot potato game. And what the hot potato game is, how liability for the cost of the case can switch hands so much. So I think it would be appropriate for me to read this for you first, because it's going to kind of get you the mindset of how, when I started doing my research, why I started researching all this stuff. But it has to do with the public defender and the position that he really holds. And it goes on, it says, if there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant. Remember rule number 1, the public and the private can never be mixed. They can't do it, and you can't do it. They don't ever mix them, so be careful that you don't either. If the defendant has a public defender, this is good. When the prosecutor signs the complaint, verifying it, and its signature is notarized, he has taken on the liability that may follow in the event it is discovered the complaint is not valid. He has taken a chance because at that point, he is the only attorney of record. He has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant until someone takes his place. He's counting on someone appearing in the case to defend against his complaint. If that doesn't happen, he is the responsible party and liable for all the cost prayed for in the complaint or associated with the statute violation. If that does happen, he is off the hook. Almost 100% of the time, that is what happens. He is pretty safe taking this chance. Usually, the straw man named on the complaint gets a good attorney to defend him. That means the defense attorney has taken on the liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney of record for the defense, he is on the hook. Now, he has to get someone to take his place. The likely taker of that position is the straw man named in the complaint, indictment, or traffic ticket. The straw man can't talk, so someone has to represent it. Usually, that is you, because you have a point to make, or a lesson to teach, or testimony that will prove your case. Wrong choice. This is almost always the losing proposition. Really good off-point paperwork has been put into court for decades with very low success rate. The only way to win is to let the state win. I love a win-win situation. How can you win and the state win at the same time? If you accept and return the presentment and exchange it for exemption for the discharge of the charges, the state gets the credits from your exemption and you get the discharge when you bond the case. Well, that sounds easy, right? If the defense attorney can get you to act as the trustee of the straw man trust named on the complaint, the defense attorney is off the hook too. It is just a series of passing the buck, a hot potato game. The one who ends up with it has to pay the bill. The prosecuting attorney starts with it. It goes on to the defense attorney if he files a notice of appearance, and then on to the straw man if you volunteer to defend, argue, testify, or join in the action in any way. It eventually ends up in your lap. You are stuck with the public liability unless you accept it and discharge it from the private side. Hot potato game, prosecuting attorney, defense attorney, straw man, and you. Now, when I first read this years ago, I used to look in the filings and notice how attorneys would file their notice of appearance. I noticed the time of it, and I started putting a picture together that something was correct about what was read right here. It's like, okay, these notice of appearance, when they put in a notice of appearance and they get the liability, but they got to make, but the first, because I noticed this is what they'll do. Once they put in that notice of appearance, your defense attorney, the first thing he's trying to do is get you to plea out. Because when you enter a plea, you accept all the liability. So I'm noticing that, I'm like, wow, as soon as he, even and sometimes what they'll do is they'll file their notice of appearance and then immediately after that file your plea agreement or whatever. They try to get you to plea out as fast as possible. And that was just something I started to notice and pick up. So I started to investigate it because I wanted to see if there was any truth to any of this. I was reading where Gene Keating was talking a lot about this on the criminal cases, and I probably do something on his stuff too. He was talking about the fieri facias and of how this is all civil and so forth. It's a lien, and so I came across this in Georgia. It's called Criminal Procedure: Assessment and Payment of Cost of Criminal Proceedings, Imposition of Cost on Prosecution upon Defendant Generally. And I started reading this, and I said the cost of a prosecution, except the fees of his own witness, should not be demanded of a defendant until after trial and conviction. If convicted, judgment may be entered against the defendant for all cost accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien from the date of his arrest on all the property of the defendant, on all the property of the defendant. The clerk shall issue an execution on the judgment against the property. All right, so we got a lot of things in here. This thing was chock full of so much information, but you're not going to find it on the internet. And this is what I try to tell people. I said, look, you got to get away from the internet because all they're going to do is just give you the code. You're not going to get the judicial interpretation of this because a layman may be on the street and read this. And if you don't know anything about legalese, you might think may means that you have some sort of discretion or something like that. When people who have a little bit more experience know that the word may means must, or you need to go and check and see if they have the definition of it in the statute. So I went ahead and went to the law library, okay, and found the official code of Georgia annotated. And I went ahead and looked this up. I said, man, I want to look this up and see if there's any truth to this. And remember, we're talking about the prosecutor and the defendant. So I went and I got it. And I noticed that you have OCGA 1711.1 is imposition of costs of prosecution upon the defendant generally. And OCGA 11.4 is imposition and costs and jail fees upon the prosecutor or complainant. So I'm like, okay, so there's one. It's one where in one situation you'll have to pay, and in another situation the prosecutor will have to pay. So I said, that sounds a lot like what's going on in creditors and their bonds. So I went on down here and I read this. And of course we have the same thing, but see in here we got the judicial decisions and where it explains what is going on, everything that is said up here in this statutory code. So down here we get some interesting things. Like right here it says judge has no discretion in the matter of taxing costs. Now, we got to look at this word tax real quick. Let's stop for a second. Let's look that up.
Sign up for this
real quick. Let's stop for a second. Let's look that up. Okay. And now I'm coming out of a Black's Law 8th edition. And you can see right here we have the word tax. And it's always important for you to look up these words because a lot of times you think you know the definition of a word until you look it up. And often you're very surprised. And additionally, you can often gain some keen insights that will lead you into some deeper understanding of the particular subject that you're studying. Right here it says tax, a noun, a monetary charge imposed by the government on persons, entities, transactions, or property to yield public revenue. Most broadly, the term embraces all governmental impositions on the property, property privileges, occupations, and enjoyment of the people, and includes duties, imposts, and excises. Although a tax is often thought of as being pecuniary in nature, it is not necessarily payable in money. Now, this was a very, very interesting sentence. I mean, and the average person, when I tell people this, it's like you really begin to see how dumbed down society is because people are just looking like in a blank stare into outer space, like, what are you talking about? I mean, pecuniary means money, okay, and it's not necessarily payable in money. Well, how else can you pay something? Like when you go to jail, they tell you have to pay your debt to society. You pay with your labor. There's a lot of different. It's not necessarily payable in money. A tax is not necessarily payable in money, and this goes right over so many people's heads. It's incredible. Um, Now, what was really interesting, it says taxes are the enforced proportional contributions from persons and property levied by the state by virtue of its sovereignty for the support of the government and for public needs. This definition of taxes, often referred to as Cooley's definition, has been quoted and endorsed or approved expressly or otherwise by many different courts. While this definition of taxes characterizes them as contributions, other definitions refer to them as imposts, duty or impost, charges, burdens, or exactions. But these variations in phraseology are of no practical importance. So I looked and said, okay, it's a charge. And you see up here, it's a monetary charge. They say they're going to give you charges. Okay. So now when we go back again and we read the criminal code and we can see the judge has no discretion in matter of taxing the cost, it gets a little bit like some insight in this. Okay, why are they using this word tax? So let's look at it a little closer. It says that these judges explain these statutes, they construe them because their job is to interpret the law. And it says, while the word may ordinarily denotes permission and not command, the use of the word in the second sentence of this section cannot be construed to mean that the trial judge is vested with discretion in the matter of taxing the cost against the convicted defendant. There is no provision of law for the payment of the fees of the officers of the court when the judge, in the judge's discretion, fails to tax the costs against the convicted defendant. And it cannot be assumed that it was ever intended that the compensation of these officers should rest in the discretion of the judge. All right. So right here, it makes some reference. It makes it seem like, okay, well, this is to pay for, um, as if it's only to pay for the fees of the officers and so forth. All right. And we're going to see that we're going to get some deep understanding of that. It says right here, and let's go down here, and you're going to see some more interesting things. And right here, this is a bond. Okay, the bond, if no supersedious is obtained, which is putting in a bond, the clerk of the trial court is entitled to have judgment awarded against the defendant for all the costs accruing in connection with the defendant's prosecution of a writ of error. All right, to the Court of Appeals while the defendant's case is pending in that court. Everything's about bonds. And notice that this is criminal now. We're in the criminal section. Okay, imprisonment for failure to pay cost. Once a judge guilty of a misdemeanor and sentenced to pay the cost of the prosecution and the default of payment thereof to be confined in the chain gang for a stated term, cannot be held in custody or compelled to labor on the chain gang for fees due officers of court for services which the officers were required by law to render in proceedings instituted by that person, subsequently to the person's conviction and sentence, to review and reverse such judgment and sentence, though liable under the judgment for such fees and costs. Once again, it's showing your liability. But right here, this is what I want to get to. Here it goes. Costs are collectible by levy of a FIFE. And if you never had heard what a FIFE is, it's a Fafere Facius. I'm going to show you. Costs in the criminal prosecution are collectible of the defendant by the levy of a FIFE at the termination of a prosecution if it finally results in the conviction of the defendant. And right here, I'm going to show you what a FIFE is real quick. Okay, and we're back in Black's Law 8th edition, and you see we have Fieri Facius, okay, which is, of course, a FIFE, all right, and it says Latin, that you have caused to be done. You did it. A writ of execution that directs a marshal or sheriff to seize and sell the defendant's property to satisfy a money judgment. Okay, so they're seizing and selling your property. What property are they seizing and selling? Okay, if every time you're convicted of a crime, okay, they have to find you guilty. They have to put these costs against you and seize your, what property are they seizing? What if you're homeless? You don't have any property. And they have to do that against everyone. Okay, it receives its name from the Latin words in the writ quod fieri facias di bonis et catilis, that you cause to be made of the goods and chattels. Look at this, man. It is the form of execution in common use in levying upon the judgment debtor's personal property. The writ of fieri facias, commonly called a writ of FIFE, which commanded literally that you caused to be made, was an early common law means of enforcing payment of a judgment. It was in effect an order to the sheriff of the court to enforce a judgment against the debtor by levy, seizure, and sale of his personalty to the extent needed to satisfy the judgment. All right. So right here, we can see, well, they try to tell you, well, it's not civil. Okay, well, right now we are in the criminal code. This is Title 17. All right. And everything in there, this is criminal procedure. Everything in here we're talking about. So what are they, first of all, what are they talking about? There isn't any such thing as this is not civil. Well, let me show you something else. So we can see right here that this is some sort of debt collection. Well, let me show you something else that looks interesting too. Interesting too. Okay, this is Georgia's debtor creditor law. Okay, and you always want to start out at the beginning of the statutes and read and see how statutes are applied. And I think it's right here in the general provisions. And right here, 1821, creation of relationship of debtor and a creditor. It says, whenever one person by contract or by law is liable and bound to pay to another an amount of money, certain or uncertain, the relation of debtor and creditor exists between them. Okay, now right here, they tell you very clearly what is going on. So if a debtor and creditor relationship is created, then you need to be looking in this chapter. Also, doesn't matter if it's a criminal case. You need to come over here and look because there's a debtor creditor relationship that's just been created, and you need to be reading debtor and creditor law. And you're going to find something that's real interesting here in the general provisions, that in the attachment proceedings, I had to find out what a writ of attachment was. And I think it's these general provisions. And right here, it says the bond requirements. Okay. So right here, it says no writ of attachment shall issue unless accompanied by a bond with good security, condition to pay the defendant all costs and damages that he may sustain in consequence of the issuance of the writ of attachment. In the event that the amount claimed to be due was not due, that no lawful ground for issuance of the attachment existed, or that the property sought to be attached was not subject to attachment, the bond shall be a sum equal to twice the amount claimed in the plaintiff's application. And this is like a replevin bond, where it's talking about this. And they talk about this replevin bond in creditors and their bonds and so forth. But what is real interesting about this is this writ of attachment. Let's look at what a writ of attachment is real quick. Okay, and we're going to stop by attachment, and then you see attaching creditor. Okay, attaching creditor. See, this is some creditor and debtor stuff. An attachment, the seizing of a person's property to secure a judgment or to be sold in satisfaction of a judgment. Okay, so that is the fundamental definition of attachment. Now let's look at what a writ of attachment is. All right, so down here in the second sense of the word, you can see the arrest of a person who is either in contempt of court, and this is what you find in admiralty, it's always contempt, or what they call contumacious conduct that gets you arrested, or to be held as a security for the payment of a judgment. Okay, this goes all the way back to Edward I when we're talking about the statute merchant, when you could be held as security for a judgment. So right here, we're seeing that, okay, one of the definitions of an attachment is the arrest of a person who's they're going to hold you as security for the payment of a judgment. All right, a writ ordering legal seizure of property and so forth. All right, so when we go back over here, it says no writ of attachment, or we saying no warrant for an arrest shall issue unless accompanied by a bond with good security, condition to pay the defendant all costs and damages that he may sustain in consequence of the issuance of the writ of attachment. This is what used to happen in admiralty. You had to go to the sheriff and issue what is called a replevin bond. Let me show you that real quick in creditors and their bonds. Okay, now we're back in creditors and their bonds, and I'm just kind of showing y'all how when I first started reading this, you know, what led me to start investigating these bonds and everything. And here right here is in the section is case bond. It says this bond is in the nature of a replevin bond. A replevin bond was formerly used in common law, equity, when there was a dispute and one party chose to file a claim in court against another party in possession of property in dispute. The moving party was required to bond his charged claim before he could get temporary possession of the subject property. The replevin bond was double the value of the subject property. Part of it was to indemnify the sheriff who seized the subject property from the defendant in possession. The other part was to guarantee the defendant would be reimbursed at least for the value of the seized property if it were not returned to him in the event he won the case. In equity, all charges need to be bonded. You've heard put your money where your mouth is. That is what is happening when charges are brought in court and the moving party bonds the case. This policy assures the defendant will not be damaged by an unsupported complaint. Charges are rarely bonded in modern court procedures until after the case is decided. By that time, the defendant is almost always in dishonor, so the prosecuting attorney can use the defendant's dishonor to bond the case. It is really the defendant's representative that is bonding the case. Again, it is the man's credit that gives life to the bond. If the defendant is in dishonor because of what his representative, trustee, said or did not say or did not do, it is the trustee's credit that is used to satisfy the debt or discharge the bond. You can voluntarily bond the case if there is no bond already in the clerk's file. Be sure to get a certified copy of the docket sheet as evidence there is no bond in the case before you issue your bond. When you bond the case, you are the creditor and the creditor wins. If you bond the case, become the creditor, and then dishonor the judge, the attorneys, or the process in any way, you will lose your position as creditor and go back to representing the defendant. All the dishonors are pinned on the defendant, even if you are the one who went into dishonor through your own words, or your actions. The defendant cannot talk or act. It all comes from you. If you bond the case and underwrite all the obligations, laws, costs of the honorable citizens of the state of whatever, that would include the attorney as long as he is honorable. If he is not, he refuses the indemnification and volunteers to have his dishonor give the commercial energy to the settlement, it is up to him. the judge will go along with what he requests. Usually, the attorney will tell the judge that the plaintiff moves for dismissal. So right here, this case bond, I want to go back up here when it's talking about double the amount. Okay, and this is what a replevin bond is, and this is what we're looking at when we get back over into 18310. It says where it has the bond shall be a sum equal to twice the amount claimed to be due in the plaintiff's application. So these are the bond requirements. If you're going to, if there's a creditor-debtor relationship, there's always a bond requirement to be put in. Okay, on both sides that the prosecution has to have before he issues a warrant for someone's arrest. And they even have down here the forms of the attachment, which is really interesting. Let me show you this. They got what it looks like, the attachment, and down here they got the actual bond that you're supposed to use. I think it's is it right here? Yeah, right here. Here's the bond right here. All right, so this is that you copy this. I put it in the caption. We, the principal and surety, jointly and severally acknowledging ourselves bound unto the foregoing defendant in the sum of X Y dollars, subject to the following conditions. The said principal is seeking attachment against the said defendant, which is now about to be sued out in the court of county. Now, if the said plaintiff shall pay all damages that the defendant may sustain, and also all costs that may be incurred by him in consequence of suing out such attachment, in the event that the said plaintiff shall fail to recover in said case, then the bond shall be void. Now, right here, this is where we get into, you see how they're hiding things in words? Okay, they're using this word attachment instead of a warrant for an arrest. Now, let's get back over into the criminal code because there's something else that I want to show you. All right, so now this was 1711. We remember right here in 1711-4, imposition of costs and jail fees upon the prosecutor or complainant. Well, let's look down here real quick and let's see if we can find something to substantiate that real quick. And down here, we get to 1711-4, and you can see it right here. Imposition of cost and jail fees upon the prosecutor or complainant. The prosecutor's name shall be endorsed on every indictment, and he shall be compelled to pay all costs and jail fees upon the acquittal or discharge of the person accused when, 1, the grand jury by its foreman on returning a no bill expresses as its opinion that the prosecution was unfounded or malicious. 2, a jury on the trial of the prosecution finds it to be malicious. Or 3, the prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all costs and enforce it by an execution in the name of the state or by an attachment for contempt. We already see that an attachment is a warrant for arrest. So now we can begin to see why the prosecutors don't never drop the charges. You're like, why won't this guy drop the charges? He's relentlessly, he won't drop the charges or anything. Well, that's why, and why also you don't go into the grand jury hearing and everything. He has to make sure he gets a indictment against you, and he has to make sure that he gets a conviction against you. If he don't do any of those things, he's the one that's responsible for paying all the cost. This is why I'm telling you to read this document, Creditors and Their Bonds. Because I went and did the research on it, and you have to really have an eye to kind of see what is, because of the language that they're hiding things in. If you don't really understand what a writ of attachment is, a fieri facias, what a case bond is, even in here, there is a picture. Even in here, there is a picture of the bond that's used to bond the case. All right, and you can see right here when you look at that, and then you look over here and you look at form of bond over here, you begin to see that this is the bond over here. We, the principal, all right, this is the bond that they have to put in. And then Creditors and Their Bonds, they also had the bond that you put in. And this is why I began to see, I said, you know what, this document, somebody whoever wrote this, they had some very good insight and some keen knowledge about a lot of different things, and on a level that I hadn't seen before. But if you start doing the research, see, a lot of you will just read documents and you don't do the research. And especially these naysayer guys, who never go to a law library, who don't look up definitions of words or anything like that, who want to go in and who are teaching you to go in and argue in a case on traverse charges and things of that nature. That's a lot of these new school guys who don't have enough, their depth of learning is just not there. They haven't been doing it long enough. So they're teaching you incorrectly. But the thing is that you have to go in and you have to start doing research yourself. Don't even listen to me. You got to really go and do your own research. But you need to really learn and see, because when you look in the codes and everything, they're taking all of this from the common law. And that's what made me start to go and look in the statutes to see if they disguised it in some kind of way. But this is evidence that, yeah, there is a debt collection. Okay, somebody's got to pay the cost. Okay, or you're going to pay your debt to society. It's going to be you if you don't bond this case and accept the charges and so forth. So this was just my little short presentation about this. Hopefully this will encourage some other people to do their own research. In other states, it's not going to be listed the same way. However, if you stick with that word attachment, it will start to help you see what is going on. If you stick with the word attachment, okay, the attachment, and everything, and stay right there because they have the same thing in all the states. The statutes are in different places and so forth, but I've always found this thing with bond requirements and the creditor and debtor law and so forth, how it has to be twice the amount and so forth. You'll see all of this. But the first thing you have to establish is that there is a creditor-debtor relationship. All right, creditor and debtor relationship. All right, once you've established that there's a creditor and debtor relationship, then you can go into the creditor and debtor law. And that was the whole purpose of going into the criminal code and seeing it. Say you're liable for all costs. All right, and they're going to execute that on you. And let me show you something else that was really interesting. And that was funny. It says cost of feeding prisoner while prisoner is in prison awaiting trial are part of court costs collectible for defendant. So while you're sitting in jail eating hot dogs and bologna sandwiches and everything, you think you're getting free food. Oh no, when they convict you, that's part of the cost they're going to collect from you too, from the execution on against your property, as it says up here. They're going to execute against your property. All right, it says the judgment shall be a lien from the date of his arrest. This is what people are saying, they're accessing your TDA account. No, and people just regurgitate what they hear. This is about creditors and their bonds. These people get create bonds, and bonds is an evidence of a debt. Okay, when you get a lien, they'll put a lien against your property, your estate. Okay, your freedom is your property. Your name is your property. Your children are your property. They put a lien against your estate, all your property. It says right here, all the property of the defendant. That's everything that could possibly be associated with you. And they put a lien, and from a lien you can create a bond, and from a bond you can sell it. I hope this is beginning to make sense to all of you. And all you people giving done down, I got a middle finger for you because you assholes ain't putting up a video and you don't know none of this stuff. So kiss my ass, all right? You need to come. I'm trying to show these people this stuff. And the thing is this is a lien. Find out. You'll find it in these books. Go and research it for yourself, and you're going to find out. Peace to the gods. I'm out.